ducky, and her ducklings always seeking justice and truth. This ducky won't be silenced by the haters, seeking out the facts while providing the receipts. She is loud with her opinions in this cruel world of villains. This ducky will talk, give her sass, while still keeping her class. So join in the pond with the ducklings from all over the place.
Hello, everybody, and welcome back to Loud Little Ducky. If you have been on this Mackenzie Shirilla ride with us, welcome back. If you are new and are not quite sure what is happening in the Mackenzie Shirilla case, Mackenzie Shirilla was found guilty on August 14th, 2023, after a 2023 bench trial in Ohio for the July 31st, 2022 car crash that killed her boyfriend, Dominic Russo, and their friend, Davion Flanagan. And so she was sentenced to 2 concurrent 15 to life sentences. So she will not be eligible for parole until October of 2037. And she has been trying to appeal ever since. Yesterday, we went over one of the motions to set aside the verdict in the case. I don't have the ruling on that, but we do know that it was denied. I just don't have what the judge said, which I would like to know what the judge said. But today, we have the 8th Appellate District Court's judgment. And that was a criminal appeal that she has the right to. And so we are going to go over that today. And then there was something else that I was going to say or show y'all, but I don't remember what it was. So while you're coming in, hit the like button. You can talk to us in the chat. I loved hearing y'all's thoughts and opinions or any information that you have that I may not mention. Subscribe so that you know when I'm going live and when new videos are out, because my schedule is very sporadic. It's not a this time every day schedule. And those are free ways that you can help the channel out. We do have memberships as well if you want to be a part of that. And the reason I had my camera off is because I got my hair did today, and I get to feel like myself again. So without further ado, new hair, who dis? This is the real me. I am normally blonde, and not being blonde has been so blah. I do have more fun as a blonde for sure. But I got my hair done. I'm super happy with it. And so we will get to Kenzie. Is this the one I want? Yes, that is the one I want. All right. Thank you, Snow Wonder. Welcome. All right. Let's make this bigger. And biggen. All right. Here, the Court of Appeals of Ohio, 8th Appellate District Court, County of Cuyahoga. Let's see how does it say? I can pronounce it. Cuyahoga. Cuyahoga. All right. Yeah. In the state of Ohio versus Mackenzie Shirilla. Judgment is affirmed, which just means that they are upholding her conviction. This was released on September 26, 2024. And it talks about appearances and Eileen Gallagher, who is a presiding judge. Now, they did ask for an en banc review, which is basically meaning in bench. And it's wanting to have a session where all the judges of the court sit to hear a case, not just one judge or a smaller panel. And that was denied. They were like, yeah, this is not important enough for all of us to get together and have a conversation. This is not it. But they tried. So there is that before we get into that. Hello, Razmataz. Defendant appellant Mackenzie Shirilla appeals her conviction for multiple counts of murder, felonious assault, and aggravated vehicular homicide. As well as drug possession and possessing criminal tools for the following or for the reasons that follow, we affirm. So we're going to get to hear kind of what they argued and what their reasoning was behind affirming. So it says a delinquent complaint was filed in the Cuyahoga County Juvenile Court, which alleged that the appellant has committed offenses of aggravated murder, felonious assault, aggravated vehicular homicide, drug possession, and possessing criminal tools. The juvenile court held a hearing to determine whether the case should be transferred to the County Common Pleas Court General Division for Criminal Prosecution. At the hearing, the state introduced evidence to support transfer. The assist with readability, we do not summarize the same evidence twice in this opinion, but rather discuss the salient disagreement between the defense and the state in our discussion of Shirilla's first assignment of error below. The juvenile court found that the state failed to establish probable cause that Shirilla committed aggravated murder, but did find probable cause was established as to remaining charges and transferred the case to the General Division. County grand jury returned a 12-count indictment charging Shirilla with 4 counts of murder, 4 counts of felonious assault, 2 counts of aggravated vehicular homicide, drug possession, and possession of criminal tools. These crimes were alleged to have caused the deaths of Dominic Russo and Davion Flanagan. Appellant waived her right to a trial by jury, and she elected to have the charges tried to the bench. Thank you, Razzmatazz. The trial court completed a judge view, visiting several locations along the route traveled by Shirilla, Russo, and Flanagan on July 31st, 2022. The parties stipulated that the defendant is the person who was driving the car at the time of the crash. Michael Galassi testified that he is employed as a police patrol officer with Strongsville Police Department. On July 31st, 2022, Strongsville Police received a 911 call reporting that the vehicle had crashed into a building near the intersection of Progressive Drive and Almeda Drive in Cuyahoga County. Galassi responded to the scene, and he testified that he observed a black car crashed into the building, and the car looked like it was cut in half. And we've seen the audio and video body cam where we hear him say that. There was heavy front end damage and appeared it was cut down the middle. Galassi related to dispatch that the situation was pretty severe. Then Galassi ran to the driver's side and saw the legs and lower torso of what appeared to be a female. The upper half of the driver's body was on the passenger side, underneath the passenger's dashboard, caved in on top of her. Galassi ran to the passenger side next, where he observed that a passenger, later identified as Davion Flanagan, was on top of the passenger seat with his back on top of the passenger seat and his head facing the top of the car. So I don't think I had heard that before. So you have the passenger seat, and Davion was like face up. When he hit the passenger seat and he was facing up towards the ceiling of the car. That's horrific. And we know that Dom and Davion were not wearing seatbelts. And Mackenzie also was known not to wear a seatbelt either, but she did wear her seatbelt when this crash happened, which is very odd. Thank you, Carmen, not Electra. Hello, Marine Wife. And Davion appeared to be deceased, as he did not seem to be breathing and had severe head trauma. Galassi continued searching the vehicle and discovered a third occupant. Galassi related that the passenger seat was reclined all the way. Okay, so the seat was like this, like basically laying backwards, and then Davion had flown or landed here, but face up. So passenger seat reclined all the way, and the third occupant was in the passenger seat with Flanagan laying on top of him. The third occupant, Dominic Russo, also had severe head trauma. Based on his initial assessment of the crash, Galassi believed that all 3 occupants were dead at the scene. As officers broke a window and began cutting the airbags, however, they heard mumbling and determined that the driver was still alive. Strongsville Fire Department arrived on scene and used tools to extract Flanagan, then Shirilla, and finally Russo. Shirilla had significant injuries to her head, or to her leg and arm. One of the first things she said was, "How is Davion?" which you would think she would ask about Dom first, but she asked about Davion first. Interesting. Emergency personnel called for 2 air ambulances, one each for Shirilla and Flanagan, who was determined to still be alive as well. Unfortunately, Flanagan died on scene before the helicopter arrived. So he was not dead on arrival, but he did die at the scene. And Dominic was dead on arrival. Galassi went to the hospital where medical personnel had taken Shirilla. He learned that alcohol testing had been conducted and Shirilla had not been under the influence of alcohol at the time of the crash. Galassi then returned to the scene to collect evidence. Officers collected 8.1 grams of mushrooms, a digital scale, 2 cell phones, a bong, a bag of marijuana, a purse, and a Cadillac key fob. On cross-examination, Galassi admitted that the Progress Drive is a cut-through street with a speed limit of 35 miles per hour. He admitted that the drivers use Progress Drive as a cut-through to get from Pearl Road to State Route 82, Royalton Road, and they often exceed the speed limit traveling on that route. Brent Robinson testified that he is employed as a patrol officer with the Strongsville Police and has driven through the area of the crash hundreds of times. He described the area as a commercial area and described the route as follows. It's a concrete paved road. It's one of our older paved roads in the city, I would say, and it's got some wear and tear to it. You can tell there is certain sections of the concrete that are raised, so it's a little bit difficult driving. I would say, like the speed limit down the road, you can feel the bumps as you are driving in your cruiser. So it seems like it's like very potholy. There's a lot of cracks and things like that. When you drive onto Progress Road from Pearl Road, it goes from east to west, and there is a series of curves that you will experience in the roadway. Mm. Once you get to the end of Progress, it's a T intersection. Robinson responded to the crash scene. The prosecution played recordings captured by cameras inside his patrol car, facing out through the front and rear windshields. The camera recorded Robinson driving at maximum speed of 54 miles per hour, and he stated that he felt this was as fast as he could safely drive on that road. It is a rough road. So even at that speed, he had to hold on to the steering wheel to make sure that he was in control. And then you have Mackenzie going basically double that. Robinson assisted with breaking windows and cutting airbags in the crashed vehicle. Dom and Davion appeared to be deceased at the scene. Shirilla was stuck underneath the dashboard, facing down in her lap. On cross-examination, Robinson admitted that Shirilla was unresponsive when he arrived on scene. Brett Stanislaw testified that he is employed as a firefighter paramedic and captain with the Burrari. He's with the fire department. He and other paramedics responded to the crash scene in Strongsville to assist Strongsville personnel because there were 3 people needing assistance. The call for aid came to them just before 6:30 a.m. on July 31st, 2022. Strongsville personnel asked the paramedics to provide aid to the driver of the vehicle who was being extricated when the Burrari personnel arrived. Stanislaw assessed Shirilla when she was extricated. Her eyes were closed when the assessment began. After paramedics began asking her questions, Shirilla gave delayed verbal responses back to them. Shirilla was confused, but alert. She was not oriented to event or place. Stanislaw said that she was confused as to what the events were, but her pulse, motor, and sensation in her 4 extremities were normal, which he said ruled out a stroke, seizure, or other significant neurological emergencies. So, Berea, Sharon coming in here with the knowledge. Berea. All right. So, thank you, because she had sensation, a pulse, and motor skills in her arms and her legs, he says that that ruled out a stroke, a seizure, or other significant neurological emergencies. So if they try this whole seizure avenue, this guy says, no, she didn't fit that. Now, I do know people who have had like a seizure or a stroke, like in their eyes and stuff like that. And it wasn't like full blown. And people have had them and didn't know them necessarily. And it wasn't, but those are a lot of times in older people. Shirilla had several broken bones and her blood pressure was elevated on scene. Her blood oxygen level was 82. When a normal level is above 95 or is 95 or above. Her heart was determined to be in sinus, normal rhythm with a normal heart rate. And like I said, she was bent down under the passenger dash. And so that with broken ribs is probably what had her oxygen levels low. Not her stupid excuse for whatever they want to call it on whatever day it is. It's not POTS, all right? During the medical assessment, Stanislaw found a baggie in Shirilla's shirt, which contained mushrooms. He also found a plastic case. He handed both of those items to a police officer. On cross-examination, Stanislaw admitted that a person could have a seizure before medical personnel arrived and that there would be no signs of it. So basically what I said. During the medical evaluation, his assessment of Shirilla was limited to his observations at the moment in the time when she was in the ambulance. Stanislaw further admitted that a blood oxygen level of 82 is extremely low. Normally, a level that low indicates that a person just went into cardiac arrest or just came back out of a cardiac arrest. That level could also be seen in a person with chronic obstructive pulmonary disorder or another respiratory ailment, but it also could be a result of a misplaced measurement device or cold fingers. Stanislaw testified that during the assessment, Shirilla was confused, her eyes were closed, she had fractured bones, she was in pain, and that she did not know what happened. And I'm sure she was not taking deep breaths during this time. Stephen Vanek testified that he is employed as a police detective with the Strongsville Police Department and was assigned to assist in the crash investigation. Shirilla's vehicle had crashed into a brick wall of a manufacturing facility operated by Plidco Company. Vanek spoke with the president of the company that operated the vehicle or facility and took photographs of the scene. He collected pieces of the vehicle from the scene and, after obtaining a search warrant, searched the car involved in the crash. Vanek also collected surveillance video from businesses located near the crash site. Finally, he used a drone to capture a video of the crash site area. Vanek authenticated the photos and drone video he took, as well as the surveillance videos he collected. On cross-examination, Vanek admitted that there is a fairly sharp turn at the intersection of Progress Drive and Almeida Drive. There is a stop sign at the intersection, but because of tree cover, a driver doesn't necessarily see the stop sign until only a short distance before the intersection. Well, they maybe need to do something about those trees then. Christopher Hench Martin testified that he is 42 years old and a friend of Dominic Russo's family. Okay, so we know how old Hench is now, because I was wondering how old he was. And he testified about an incident that occurred, we know, July 17th, 2022, before the crash. On that day in July, Hinch was sitting with Dominic's mother, Christine Russo. When Dominic called Christine, Dominic seemed upset. Christine grew upset, and Hinch agreed to drive to go get him out of the situation that could have been a bad situation. Hinch called Dominic on the way in order to obtain his exact location and ultimately located the vehicle which Shirilla was driving and in which Dominic was the passenger on the shoulder of Interstate 71 because she had pulled over. Hinch was on the phone with Dominic at the time as both cars were pulling over. Hinch heard Dominic and Shirilla arguing. During the course of the argument, Shirilla said, "I'm going to wreck this car right now." Dominic moved to exit the vehicle when it came to a stop. Hinch testified that he saw a tussle inside the car with Shirilla swinging her hands at him. That's not a surprise. Dominic exited Shirilla's car, entered Hinch's car, and Hinch drove Dominic back to the Russo home. Dom was upset. On cross-examination, Hinch admitted that Christine Russo owns two houses next door to each other. Christine lives in one house with two of her sons, and in July of 2022, Dominic was living in the other house with Shirilla. Hinch further admitted that he did not report the incident on the highway to police. No, because they had it handled, and they didn't want to do all that mess. So she had a jury view, or like a jury view basically of the scene and the route. Yep, she was coherent in the rescue squad. And I just can't imagine them not doing, you're saying an EEG scan. I just can't think that they wouldn't have done all the different scans with her because of, one, how bad she was off, and the fact that the other two had died. Okay. According to Christine Russo, Dominic and Shirilla had met in school and had been dating for approximately 4 years at the time of the crash. Christine considered Shirilla to be part of her family, and they spent a lot of time together over the years. Shirilla moved in with Dominic in December 2021 or January of 2022. In the 6 months before the crash, Christine observed that the relationship between Dominic and Shirilla became strained. She observed fighting, arguments, disagreements, breakups, and threats. She reported that Shirilla became more possessive of Dominic, which we have seen evidence of that ourselves. And nobody's saying that Dom wouldn't possibly act the same way with her. And we've heard I've heard Shirilla talk about, they don't ever talk about what he's done to me. The thing is it doesn't matter what he did to you, because you didn't have a right to kill him. Now, if it was you that had been killed, then we would focus on Dom's part. But you're not the victim, Mackenzie. It's not woe is Mackenzie. There came a time in August or September 2022 that Christine and Shirilla were together at Dominic's grave. Christine asked Shirilla why they did not ask for a ride on the day of the crash. Shirilla responded that they were not effed up. Shirilla and Christine also communicated by text messages about the accident. Shirilla texted Christine the following: I remember turning onto the street and then my vision fades to black. It really kills me not to be able to remember anything. I promise you I would tell you. I've been asking my therapist why I don't remember, and she said it's because of trauma. I'm going to try to get myself hypnotized and make myself remember. And there will be jail calls that do discuss her wanting to be hypnotized. She has not, well, the whole time she was in county jail before she had got moved to a prison, there is a jail call where she does talk to her mom about wanting to be hypnotized. It doesn't seem like Natalie's interested in her getting hypnotized, but Mackenzie wants it. Christine confirmed the accident on July 17th, or incident, not accident. There's a big distinction. July 17th, 2022, where Dominic called Christine and needed to be picked up immediately, and that Christine asked Hinch to pick up Dominic and to return to her house approximately half hour later, and that Dom was upset when he returned. After Dominic died, Christine Russo was provided with 3 videos of Shirilla and Dominic on a phone that had been inside of Dominic's house, which she provided to the police. Christine testified the videos had been made in July of 2022. So July was not a great month for them. But they were just so lovey-dovey. After the incident on the highway, based upon the content of the conversations between Shirilla and Dominique, had been recorded on a phone owned by William Ellis. The phone had been in Dominic's home and was returned to Ellis, who then discovered the video recordings. The court allowed the videos to be played over defense's objection that they were inadmissible under the 404B rules. So this is another objection that was done by her trial counsel. In the video, Shirilla can be heard threatening Dominic, threatening to break into his house. Paul Berlinghaus testified that he is a 19-year-old and has known Shirilla since they were in middle school together. He knew Dominic Russo through Mackenzie and knew Davion Flanagan through mutual friends. Berlinghaus testified that at approximately 11 p.m. on the evening of July 30th, 2022, Russo, Flanagan, Shirilla, and other friends came to Berlinghaus's house to hang out. They listened to music, and a few of them smoked marijuana. Berlinghaus did not smoke, and he did not believe Mackenzie did either. The tone of the get-together was quite chill, just like a normal sleepover. No one drank alcohol or used any other drugs than marijuana. Berlinghaus went to sleep sometime after midnight and woke around 3 or 4, at which time Mackenzie was asleep on the couch. Flanagan was watching a television program with another one of his friends, but Berlinghaus did not see Dominic at the time. So I wonder where Dom was. Berlinghaus went back to sleep, and when he arose later in the morning, all guests were gone. One of his friends texted him to tell him about the crash. and that he could not believe it. On cross-examination, Berlinghouse admitted that he did not see Mackenzie and Dom fighting at the get-together. Everything seemed fine between them. Tyler Croy testified that he is 19 years old. He knew Mackenzie because they were classmates in high school, and then he knew Dominic through mutual friends. Croy and Davion Flanagan were pretty good friends throughout high school and after they graduated. Croy and Flanagan were connected on social media applications, Life360 and Snapchat. Life360 is an app that tracks users' location through their mobile phones and makes location information available to approved connections. Snapchat allowed the two to exchange photographs and electronic messages. Croy was out of the state on July 30th and 31st, but he communicated with Flanagan over Snapchat in the early morning hours of July 31st. When Croy heard that Flanagan had been involved in a car crash, Croy took screenshots of Flanagan's location data as recorded by Life360 and provided that information to the police. We saw that police interrogation and those screenshots. And yes, no thanks, MK. My hair's changed. So let's see here. The location data showed that Flanagan was at, I don't know how to do all that. I don't know how to do all of that. And then underneath, it's dark underneath. Oh, I can't do that. I'm sitting. That would be weird. I would look like a dog on all fours. The location data showed that Flanagan was at home on Brushwood Lane in Strongsville from 11:39 p.m. to 5:30 a.m. The application recorded that Flanagan was traveling from 5:30 a.m. to 5:36 a.m. Yes, I saw Gingras was back again. At which point they crashed. The application recorded Flanagan was moving at 90 miles per hour. On cross-examination, Croy admitted that his understanding of the Life360 data is simply from being a user. He is not employed by the application and is not an expert on it. Croy also admitted that while the application records phone usage, it does not document who in particular used Flanagan's phone. Well, right. It just that it was on him. And that somebody on, yeah, I know. Has he said something else? Okay. Is it Twitter that he's back on? Yeah. Boy, he's been busy. He's got so much free time. Go charge your phone, of course. All right. On cross-examination, Croy admitted that his understanding of Life 360 data is simply from being a user. We already read that part. Okay. Kelly Varaha testified that she is 19 and she met Mackenzie through mutual friends in 2020, and the two became friends themselves. He is very much. I love the Life 360 app too. I used it today when I was at my hair appointment. My daughter left and I was like, do I need to close the garage? That's okay if Jingris Law is down because we have everything backed up anyways. Have a good evening, Sarah. All right. Back to the motion. On July 30th, 2022, Varaha hosted a graduation party. The party was laid back with friends hanging around by the fireplace and playing some games. Mackenzie drove to the party at around 10:15, 10:30 with Dom and Davion. Varaha welcomed them, and Mackenzie asked Varaha if I trip, and Varaha responded that she did not. The three guests had brought a bottle of tequila and a weed pen with them, and she saw Davion holding the weed pen. Mackenzie, Dom, and Davion were debating on going to somebody else's house, or they were debating on tripping that night. And it doesn't sound like they tripped. They did go to somebody else's house. Mackenzie, Dom, and Davion stayed at the party approximately 25 to 30 minutes, during which time Varaha did not see any of them using drugs or drinking alcohol, and they left. Angelo Russo testified that he is 24 years old and is Dom's brother. That's crazy. They were like, Angelo and Dom were only like 3 years apart, 4 years apart. Russo met Shirilla when she and Dom began dating, and that Shirilla was over Angelo's house a lot. According to Angelo Russo, Shirilla and Dominic had broken up many times over the years, and in June and July 2022, Dom was considering ending their relationship for good. Can you imagine 4 years of Mackenzie, even if it is on and off? Hello, Bacon Bears. It would just be horrible dealing with her. Shirilla sent Angelo a few text messages after the crash, which Angelo provided to the police. In an August 6, 2022 text, Shirilla asked Angelo, would you be able to go in Dom's room and grab some photos from his desk of me and him so I could put them into a casket so he can be with me forever? Shirilla sent him another message later that month in which she apologized for the crash and said, I know you probably think this is all my fault. I wish that he was here too. This should have never happened. I really do feel bad. It's killing me. Adam McQuaid testified that he is employed as a sergeant with the Brooklyn Police Department. So this is just going through all the trial people. He is a member of a regional crash team that analyzes and reconstructs traffic crashes in the area. The party stipulated that McQuaid is an expert in accident reconstruction and forensic event data recorder analysis, so EDR analysis. The Strongsville Police Department requested McQuaid to review data taken from the event data recorder in the Toyota Camry involved in the crash. From his analysis of the EDR, McQuaid concluded that the vehicle's accelerator pedal was fully depressed 4.6 seconds before the crash. The engine throttle was also at 100% until 1.6 seconds before the crash, when the vehicle went airborne as it went over a curb. Within 4.5 seconds of the start of the crash, the vehicle registered a small right turn, then a small left turn, followed by a significant right-hand turn that caused the data recorder to note a rollover event, meaning that there was enough lateral force on the car that the data recorder thought it was turned over. Had there not been a brick wall there, it might have. He explained that the car was traveling very fast, and then there was a hard yank of the steering wheel, turning the wheel 140 degrees. Yeah, they're going to need to explain that 142 degree wheel turn. What is happening here? Yes, don't be. You're not invincible, even though us mamas like to think we are. The car registered a small change in velocity as it hit the curb, and then a large change in velocity as the vehicle hit a wall. The vehicle hit the wall 1.1 seconds after the hard steering event. That makes sense to me too. Is trying to save themselves. Because I mean, and the thing that kills me the most is that there were I love you texts sent like right when the crash was somewhat in process, or like 1 minute prior to the crash. And that tells me that they saw their death coming, which is horrible. Because I don't think they were just all in their feels wanting to tell their parents that they loved them and stuff like that. At no point in the 4.6 seconds before the crash was the brake pressed. On cross-examination, McQuaid admitted that the data does not show what caused the steering wheel to take a hard right turn. He further admitted that the side airbags deployed approximately 30 milliseconds after that hard steering event. He further admitted that it is accepted in his field that it takes a person 1.5 seconds to react to something they have perceived. The data available from the computer was limited to the last 4.75 seconds before the vehicle hit the wall. Esther Singh testified that she is employed as a trauma surgeon at the Metro Health Medical Center. The parties stipulated that Dr. Singh is an expert in the field of trauma medicine, and that Mackenzie was examined on July 31st, 2022, after the crash. According to medical records, Mackenzie reported pain everywhere. An exam determined that her airway was intact, her breathing and circulation were normal, and her pupils were reacting normally. She was alert and oriented. Probably after they got her out of the car and got her out of that position and laying down. They really must have been terrified. A physical exam revealed that Mackenzie's right elbow and right knee appeared abnormal, and there were 2-centimeter lacerations to the left knee. Shirilla's mother informed medical personnel that Shirilla had a history of postural orthostatic tachycardia syndrome, POTS, which can cause a patient to have an unusually elevated heart rate. You know what also can cause accelerated heart rate and higher blood pressure? Pain. Pain, for sure. Drugs, yeah, those could cause it. Was there supposed to be stuff on the podcast today? According to the medical records, Shirilla denied drug use when asked by medical personnel, and a blood alcohol tested reflected not detected. Well, see, then you're lying because whether you think pot, weed, whatever is a drug or not, it is. Some drugs are legal and some are not. Medical personnel did not note any cardiovascular neurological, joint, or muscle symptoms. No symptoms related to sleep disturbances, anxiety, memory loss, disorientation, inattention, or depression were noted, and an electrocardiogram, which was performed, revealed that the electrical function of Shirilla's heart was normal. So they did do a cardiogram on her. So I'm saying there are things. This was done when she was in the hospital right after the accident, like the day of the accident. A medical record does not medical record does note that Mackenzie reported feeling depressed and felt grief, guilt, and shame. She said she wanted to die and expressed that it was her fault for killing her boyfriend. And you can have, she can have those thoughts. Like that is not abnormal to feel all those feelings at that time. On cross-examination, Dr. Singh admitted that a blood oxygen level of 82 would be abnormally low for most people. Dr. Singh further admitted that a patient with POTS may experience dizziness or a headache. Medical personnel evaluated Shirilla approximately 2 hours after the reported time of the crash. A person who has suffered a seizure or a mini stroke could possibly have recovered within 2 hours. So there was a cross-examination done where they talked about the POTS and all that stuff. So this is where that ineffective assistance of counsel, this is why I don't think it is going to be a thing here, because you basically have to fall asleep and not file motions or anything to be considered ineffective. evaluated Shirilla approximately 2 hours after the report time of the crash. Okay, we read that part. Michelle Ruminski testified that she is employed as an investigator of the Ohio Bureau of Motor Vehicles Investigation Section. B&V records indicated that when applying for a temporary driver's license after the accident, Shirilla attested that she did not have any condition that results in an episodic impairment of conscious or loss of muscular control. She further attested that she does not have a physical or mental condition that prevents her from exercising reasonable and ordinary control of a motor vehicle. Shirilla received a driver's license on October 21st, 2022. Shirilla had made the same attestations to obtain her previous license, which was issued in April of 2021. So in 2021 and in 2022, before the accident and after the accident, there is no mention that Mackenzie has problems that would mess herself up from driving, that she should be totally normal driving. And her parents let her drive after that crash. Yes, please hit the like button. You can share it out too if you want. Mark Sargent testified that he is employed by a consulting firm known as Fire and Explosion Consultants, where he conducts mechanical defect analysis on automobiles. The parties stipulated that he is an expert, forensic mechanical expert. He was contacted by Strongsville Police to evaluate the Toyota Camry driven by Mackenzie to determine if there were any mechanical failures that may have caused or contributed to the crash. Sargent inspected the vehicle on August 30th, 2022. There had been a recall for the vehicle, but Sargent confirmed that the issue had been adequately repaired by a Toyota on this particular vehicle. Right. We saw that. She had actually had the recall issue fixed already. But nice try. Sargent thoroughly examined the vehicle, including but not limited to the accelerator pedal, the throttle mechanics and brakes. He found no indication of any pre-crash mechanical or electrical failure that may have caused a loss of accelerator control, a loss of braking, or a loss in the ability to steer the vehicle. Sargent noted that the vehicle components were partially buckled over. The accelerator pedal, which combined with information that a slipper was found trapped underneath the rolled over component, caused him to conclude that the driver's foot was on the accelerator when the crash occurred. And because of the location of the slipper on the pedal, the slipper could not have been caught in such a way that it caused unintended acceleration prior to the crash. So the slipper gave that away. Prada betrayed her. Betrayed her so much. Sargent testified that he did not see any indication that the brakes had been applied for a long period of time in an attempt to stop the vehicle before the crash. The brakes appeared functional. Sargent researched the mechanical specifications of the vehicle. It was capable of going from 0 to 60 in about 7.5 seconds. It could go from 0.5 miles an hour to 102.5 miles per hour in 26.5 seconds. And the maximum speed of the vehicle was 129 miles per hour. On cross-examination, Sargent admitted that the event data recorder from the vehicle showed that both front seatbelts were engaged. Ooh, that'll be fun to go see the movie. All right. So it showed that seatbelts were engaged. I wonder if Dom just buckled the seatbelt, like, so that the car wouldn't, like, just sit there and ding and yell at you, because my car does that. My mom's car is even worse. I yell at the car all the time. Like, when I'm in a parking lot, I'm like, shush your mouth. The data showed that the gear shift was shifted back and forth between drive, sequential, and neutral. What is sequential? I haven't heard that used. Sequential manual transmission, also known as, is a type of non-synchronous manual transmission used by motors. It produces faster shift times than traditional. Okay. That didn't really tell me anything. But it went between drive, sequential, and neutral in 4.7 seconds before the crash. The gift shear has to be manually moved. Sargent calculated that this vehicle could go from 50 miles per hour to 100 miles per hour in approximately 19 seconds. In 17 seconds, it could go from 60 miles per hour to 100 miles per hour. Sargent further admitted that a hard right turn could be consistent with a driver attempting to maintain or get control of the vehicle. It could also be consistent with a passenger pulling on the wheel trying to avoid a collision. It could have also been a physical reaction caused by the impact of the vehicle hitting the ground after becoming airborne. It is possible that a driver attempting to brake may accidentally hit the accelerator, but he said that normally in that situation, he would expect to see a data recorder capture that the accelerator go from 100% to 0 at some point. So they tried to do the argument of, well, she could have accidentally pressed the accelerator and not press the brake, which, I mean, yeah, but most drivers don't do that. New drivers can, but I don't see why she would do that. But I mean, I guess you throw spaghetti at the wall. All right. Because her car was an automatic. I don't think it was a manual car. I could be wrong. Well, I mean, she is a dodo bird. I'll give you that, Texas. On recross examination, Sergeant testified that the hard right turn happened nearly simultaneously with the vehicle hitting the curb. Joseph Fellow testified that he is a medical doctor. I am Dr. Fellow, and I am on my fellowship. Dr. Fellow reporting for fellowship. But he was employed as a forensic pathologist and a chief deputy medical examiner by Cuyahoga County Medical Examiner's Office. The party stipulated that Dr. Fellow is an expert in the field of forensic pathology, and court accepted him as an expert. The medical examiner's office concluded after its examination that Flanagan and Russo each died from multiple blunt force injuries consistent with an automobile crash. Davion's lethal injuries were to his trunk and abdomen. Russo's lethal injuries were to his head. Toxicology tests showed that Davion and Dom had both used marijuana before their deaths. The manner of these deaths was initially classified as an accident based on a report from Strongsville Police Department indicating that the death was being investigated as a traffic accident. But then, in March 2023, the prosecution submitted additional evidence to the medical examiner's office and requested a reconsideration of the manner of death for the victims. The additional evidence consisted of transcripts from cell phones, still photographs, video images, and interviews with various witnesses. Based on that additional information, Dr. Fellow amended the autopsy report for the victims, changing the cause of death from accident to homicide. The report indicates that the investigation revealed the driver's intention of infliction of self-harm and harm unto the passengers in her vehicle. On cross-examination, Dr. Fellow admitted that the manner of death was changed for each of the victims based in part on evidence that Mackenzie intended to unalive herself. Which, oh, thank you for the jewels. Snow Wonder, I appreciate it. A Sunday. I wish I could get me a Sunday right now. All right. And personally, I think this could be, and they do have a problem a bit with this medical examiner changing the death certificate, and we'll get to that, I believe. But I can see the medical examiner changing this to an unknown, which doesn't keep the prosecution from going after them. Elliot Rawson testified that he is employed with the Ohio State Highway Patrol in the crash reconstruction unit. The parties stipulated that he is an expert in crash reconstruction. Rawson completed a time distance analysis in relation to the crash. Rawson visited the scene of the crash and used forensic mapping surveying tools to take the relevant measurements. He reviewed the surveillance video of the crash and analyzed it. He concluded that the vehicle was traveling at an average of 88.86 miles per hour over the 2 seconds leading up to the crash. It was traveling approximately 97 miles per hour before leaving the roadway. He concluded that the vehicle was gaining speed before leaving the roadway. From when it left the roadway to when it crashed into the building, it was traveling at approximately 80.5 miles per hour. Then they get into Detective Hazoo testified that he is employed as a detective with Strongsville. He obtained surveillance video from, cameras on the date of the crash that showed the Toyota Camry approaching Progress from southbound Pearl Road before making a controlled turn from southbound Pearl onto westbound Progressive Drive. Hazoo submitted that the suspect's mushrooms recovered from Shirilla by medical personnel to the lab for testing. The lab confirmed that the substances weighed 6.91 grams and was 95% psilocybin mushrooms. Hazoo interviewed Mackenzie in the hospital, during which she made a statement either to him or to her mother in his direction about take my license away for 10 years. So she's saying that in July of 2022, take my license away for 10 years. And then what does she do in October? She goes and renews her driver's license. Yeah, when you hit a curb, it's going to slow you down. For sure. GPS data from Shirilla's phone recorded that Shirilla's phone was located in the area of Progress and Alameda on July 28th, 2022. So this is talking about her driving that route earlier. On cross, Hazoo admitted that a location ping from a cell phone gives a general location, not with pinpoint accuracy. He further admitted that Shirilla was under the influence of marijuana at above the per se level at the time of the crash. Hazoo revealed Shirilla's social media history and documented over 100 instances of what he would characterize as distracted or reckless driving. On redirect, Hazoo testified that he did not believe that Shirilla was impaired by marijuana when she was driving. No, it was something she did daily. He noted that the investigation revealed that she was a habitual marijuana smoker and that she smoked marijuana while driving. Yep, all day, every day. After the state rested its case, the defense moved for a judgment of acquittal pursuant to Criminal Rules 29. The court denied the motion. So they were like, hey, you don't even need to hear. The defense was like, we don't even need to hear from us because the state hasn't met their burden. And the judge was like, denied. Have fun at the movies. The defense then called a witness in its case, the produce lady, and she testified that she owned an organic produce market in Strongsville and that Mackenzie was a regular shopper in her store. She would often come to the store with Dom, and they were together at the produce place 2 or 3 times a week. Yeah, because Mackenzie couldn't even shop at a regular grocery store. Which, great, support your local produce people, but it's just, she's just so, I don't know. The many times she thought that Mackenzie and Dom together, they appeared loving, they held hands, had her arms around each other. You could tell they were very much in love. They're 2 teens, really. Candace Shipley testified that she is Mackenzie's aunt. 2 days before the crash, Mackenzie and Dom came to Shipley's house and stayed for about 3 hours. And Mackenzie's aunt saw no signs of discontent or unhappiness between them. They were very much in love and spoke of future plans together. Natalie Shirilla testified that she is Shirilla's mother. And according to Natalie, she never heard Mackenzie express unaliving thoughts prior to the crash. And she testified that Mackenzie was living at the Russo house. With respect to Mackenzie's physical health, Natalie has seen Mackenzie suffer symptoms from POTS at least twice. Natalie described her understanding that the condition can cause low blood pressure and an increased heart rate and can cause someone to lose consciousness. On cross-examination, Natalie testified that Mackenzie was diagnosed with POTS in 2017 at the Cleveland Clinic. Natalie could not remember the name of the doctor who made the diagnosis. Natalie took Mackenzie to the doctor after Mackenzie fell to the kitchen floor on one occasion. The doctors made the diagnosis and gave Mackenzie salt tablets to treat the condition. Mackenzie would take the tablets or eat a salty food as needed. So there were times she wasn't taking the salt tablets. Could she just have low sodium? My grandma had low sodium. I know a bunch of people have high sodium, but that stuff can make you feel dizzy and pass out too. Since the diagnosis, there have been a couple of occasions where Shirilla would feel herself feeling low in salt or woozy and would sit down and eat some crackers and another salty food. The bitch needed to eat. That was all it was. Had she just eaten like a normal person, she would have been fine. Her diet was causing these things. That's the problem with some of these diets and diet fads that are out there is, yeah, you can lose weight. It doesn't mean that it's being done healthy. You can be skinny. Doesn't mean you're doing it properly and that it can't cause medical problems. Natalie admitted that she helped Mackenzie apply for her driver's license twice since the POTS diagnosis was made, and neither time disclosed the condition. Natalie testified that Shirilla had experienced a pot episode a week or two before the crash and reported it. It was really bad. It hadn't been that bad in a long time, and she was scared it was going to get worse. Natalie admitted that she did not take Shirilla to a doctor or limit Shirilla's driving privileges. Come on, Mr. Prosecutor. You think that Mackenzie can be told what to do? All right. You think Natalie can tell Mackenzie what to do? That's cute. Natalie's statement on direct that Mackenzie had never threatened unaliving was impeached with the police report from March 23rd, 2020, that reflected that police and fire personnel were dispatched to the Shirilla home to respond to a 15-year-old female who had threatened unaliving. The police went on to report that Shirilla would not be transported to a hospital because her parents did not think her threats are real and did not believe she would hurt herself. So why did Steve call the police then? Because Steve was the one that called him. So Natalie was caught lying on the stand. And they're like, I don't know why they even brought up that 2020 incident. The 2020 incident was like 2 years ago. Why does that matter? Because you're a liar and you said Mackenzie had never done anything like that. You also knew your daughter was a horrible driver and you still let her drive. This is why parents can be charged with murder when you let your kids have access to a deadly weapon, and a car can be considered a deadly weapon. Defense renewed its criminal rule 29 motion before the court returned its verdict, and the motion was denied. The court found Mackenzie guilty of all charges. The court commented specifically on the video exhibit showing the crash, calling the crash chilling and tragic, and stated that the video clearly shows the purpose and intent of the defendant to cause death. It noted that Shirilla made the decision to drive a car, to drive an obscure route, a route she visited a few days before, and a route not routinely taken by her. It noted that Mackenzie chose to drive early in the morning when few people would be around to witness the accident or provide help. It concluded that Mackenzie intentionally pressed the pedal to the floor, taking the car to nearly 100 miles per hour and aiming the car at the brick wall. The court stated that it could only be speculated whether she intended to harm herself, but it concluded beyond a reasonable doubt that Mackenzie acted purposefully and intentionally to kill Dom and Davion. Her actions were controlled, methodical, deliberate, intentional, and purposeful. Go off, Judge. Snaps for Judge. At the sentencing hearing, the parties agreed with each other as to murder issues, leaving the court to sentence Shirilla on 4 offenses. Counts 1 and 2, murder, each an unspecified felony in violation of RC 2903. Okay, so count 11, drug possession, 5th degree felony. Count 12, possessing criminal tools, a 5th degree felony. The court imposed a sentence of 7 months in prison on the drug possession and credit for time served on the possessing criminal tools. So she basically, before trial, had basically served her possession charge. And let's see. And the court suspended Mackenzie's license for life based on her convictions for aggravated vehicular homicide. As she should. Mackenzie will always need a driver. Hello, Rob. How are you? The parents could have been charged 716 for sure. They really could have. Family members of the victim then addressed the court. The state addressed the court, showing videos and photographs of Mackenzie at a concert celebrating Halloween. That she lacked remorse for her actions, refused to acknowledge that the crash was intentional. One of Mackenzie's family members addressed the court, as did Mackenzie. The defense addressed the court and presented numerous letters in mitigation of the sentence, calling the crash the horrible, terrifying, and tragic result of selfish, intentional, and cruel decision by Mackenzie. The court sentenced her to serve an indefinite sentence of 15 years to life in prison on each of the murder counts. The court ordered all sentences be served concurrent, so at the same time. Mackenzie appealed, raising the following assignments of error for review. So their first assignment of error was that they aired the juvenile court error when it concluded that the state presented sufficient credible evidence to demonstrate probable cause to believe that Shirilla purposely and knowingly caused the deaths of Dom and Davion. So that it shouldn't have been a thing over in juvenile to go over to adult. Assignment 2, the state failed to introduce sufficient evidence to sustain the convictions in violation of Shirilla's rights to due process of law as guaranteed by Article 1, Section 10 of Ohio's Constitution, as well as the 14th Amendment of the United States Constitution. Assignment 3 was Shirilla's convictions are against the manifest weight of the evidence. I disagree. Assignment 4, the trial court erred by permitting the state to introduce character and or other acts evidence during its case in chief, thereby depriving Shirilla of the rights to a fair trial in violation of the United States and Ohio constitutions. And the assignment 5, error. The trial court erroneously precluded the defense from introducing testimony and or evidence related to July 17th incident, thereby prejudicing Shirilla's constitutional right to due process and a fair trial, as well as her right to present a meaningful and complete defense. We addressed Shirilla's assignments of error in a slightly different order than she presented them. Mackenzie contends that her convictions were not supported by sufficient evidence. While she challenges the convictions on each of counts 1 through 8, we note that counts 2 through 8 merged into other offenses at sentencing. Therefore, any error with respect to the sufficiency or manifest weight of the evidence on counts 2 through 8 is harmless beyond a reasonable doubt. See State v. Ramos, 2016 Ohio case. When counts in an indictment are allied offenses and there is sufficient evidence to support the offense on which the state elects to have the defendant's sentence, the appellate court need not consider the sufficiency of evidence on the count that was subjected to merger. Okay? Because any error would be harmless. Because she really wasn't fully sentenced on all the different counts. She had the drugs ones and then the murder ones. Instead, I mean, the judge could have been like, all right, let's go through all 12 counts and it's going to be this for this one, this for that one, all the way through 12. But the judge didn't do that. The judge basically sentenced her on 4 things. A challenge to the sufficiency of evidence supporting a conviction requires a determination of whether the state has met its burden of production at trial. Whether the evidence is legally sufficient to support a verdict is a question of law. An appellate court's function when reviewing the sufficiency of evidence to support a criminal conviction is to examine the evidence admitted at trial to determine whether such evidence, if believed, would convince a reasonable juror of the defendant's guilt beyond a reasonable doubt. State v. Bankston, 2009 Ohio case from the 10th District, noting that in a sufficiency of the evidence review, an appellate court does not engage in a determination of witness credibility. Rather, it essentially assumes the state witnesses testified truthfully and determines if the testimony satisfies each element of the crime. We must determine whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime proven beyond a reasonable doubt. The elements of an offense may be proven by direct evidence, circumstantial evidence, or both. Circumstantial evidence and direct evidence have equal evidentiary value. A person commits murder by purposefully causing the death of another. Shirilla concedes that the only issue in dispute was whether Shirilla crashed the vehicle purposely. She argues that there is no evidence that she acted purposely, and the appellate court says, we disagree. And they talk about a witness that testified that less than a month, he had heard her threatening to crash and stuff like that. On the date of the crash, did make a controlled turn and all of that, then pushed the pedal all the way at 100 miles an hour. And someone inside the vehicle manually shifted the gears into neutral. But it was forced back into drive as the vehicle continued hurling forward. And Shirilla never took our foot off the accelerator and never depressed the brakes in the seconds leading up to the crash, even as the car passed through an intersection, went airborne, landed, continued through an industrial sign and into a brick wall. She didn't press the brake once and never took her foot off the accelerator during all of it. Intent. Can you imagine having your foot still on the accelerator after all of that and not braking? Medical experts examined Mackenzie after the crash and could find no evidence that she had been afflicted with a neurological or muscular condition that could have contributed to the crash. They looked, they were hoping to find something, and that this was not what it was seeming as. They were hoping it was an accident. A mechanical expert examined the vehicle and found no sign of latent defects that could have contributed to the crash. The evidence was sufficient for the fact finder to conclude beyond a reasonable doubt that Mackenzie crashed the vehicle purposely intending to kill Davion and Dom. We therefore overrule Shirilla's second assignment of error. Shirilla contends that her convictions were against the manifest weight of the evidence. A manifest weight challenge attacks the credibility of the evidence presented and questions whether the state met its burden of persuasion at trial. When considering an appellant's claim that a conviction is against the manifest weight of evidence, the Court of Appeals sits as a 13th juror and may disagree with the fact finder's resolution of the conflicting testimony. The reviewing court must examine the entire record, weigh the evidence and all reasonable inferences, considering the witness's credibility, and determine whether, in resolving conflicts in the evidence, the trier of fact clearly lost its way and created such a manifest miscarriage of justice that the conviction must be reversed and a new trial ordered. Reversal on manifest weight grounds is reversed for the exceptionally case in which the evidence weighs heavily against conviction. To me, that would have been Karen Reed if Karen Reed would have lost. Shirilla contends that the weight of the evidence establishes that Mackenzie and Dom's relationship was in a good place at the time of the crash, and that Berlinghaus and Veraha saw them shortly before the crash and didn't report anything out of the ordinary. Others who knew Mackenzie and Dom had also testified that the two seemed to be in love. Shirilla points out that her POTS condition may have led to a medical issue that caused the accident, or she may have had some other medical emergency like a heart attack or seizure. Shirilla posted that the crash could have been caused by distracted driving or simply reckless, contrary to the testimony of Detective Hazoo, that Mackenzie often drove distracted or reckless, according to her social media. She argued that in light of all the possible other explanations, the manifest weight of the evidence weighs against the verdicts. After a careful review of the record, we find that this is not the exceptional case where the evidence weighed heavily against the verdicts. So they do not agree with you. And Mackenzie is not exceptional, like she thinks she is. A conviction is not against the manifest weight of the evidence solely because a fact finder heard inconsistent or contradictory testimony. While the jury may take note of inconsistencies and resolve or discount them accordingly, such inconsistencies do not render defendant's conviction against the manifest weight or sufficiency of evidence. The decision whether and to what extent to believe the testimony of a particular witness is within the peculiar competence of the fact finder who has seen and heard the witness. Right. It really is. That is so sad that tomorrow is the anniversary. That's so sad. Here, the record reflects that the fact finder was persuaded by forensic reconstruction evidence and other evidence showing that the constant maximum acceleration leading to the crash in connection with Shirilla's previous threats and the fact that her cell phone had been located in the area of the crash in the days leading up to the crash. In connection with Shirilla's previously threats and the fact that her cell phone had been located in the area of the crash days leading. While certain friends and family testified about the loving nature of the relationship, other witnesses testified that they saw them significant fighting. The latter claim was corroborated by video evidence. Yeah, because all the other stuff is like, it's just people talking. But when you have photographic and video evidence of something else, those are going to speak louder than just somebody up there with bias of some sort talking about it. Testimony established that these fights involved Mackenzie threatening Russo and hitting him in one instance. While Singh testified that it is possible that Shirilla could have suffered a medical emergency and still appear normal in the medical examination, within the 2 hours or after 2 hours, other evidence makes this potential explanation seem unreasonable. For example, Shirilla denied having the adverse medical conditions when applying for driver's license, both before and after the crash. Moreover, someone manually moved the gear shift back into drive after it was moved into neutral in seconds before the crash. And I wonder if Dom moved the gear shift. I mean, Davion could have done it too, but maybe that was his way of trying to do it. And I don't know what would have happened if somebody did like the emergency brakes or something. That would have made the car spin and probably crash too, but there was no evidence presented that any medical condition could have caused Mackenzie to simultaneously lose the ability to take her foot off the accelerator or hit the brakes while also intentionally manipulating the gear shift. A distracted driving incident is also not consistent with the forensic evidence, which shows that Shirilla never took her foot off the accelerator, even as the car hit a curb, went airborne, landed, and continued toward a brick wall. Mackenzie argued her case to the trial court, and the court was permitted to reject any portion of the state's evidence or witness testimony that it was inconsistent or otherwise unbelievable. We cannot say that this is the exceptional case in which the evidence weighs heavily against the court's verdict. We therefore overrule Shirilla's third assignment of error. Then we get to the first assignment of error, that Shirilla contends that a juvenile court erred by transferring her case to basically the adult court. Her argument largely tracks her sufficiency argument above, namely that the evidence presented during the probable cause hearing established that Mackenzie and Dom were in love and getting along perfectly fine before the crash, and that there was insufficient evidence that Shirilla purposely crashed the car. Juvenile courts possess exclusive jurisdiction over children alleged to be delinquent for committing acts that would constitute a crime if committed by an adult. However, under certain circumstances, the juvenile court has the duty to transfer a case or bind a juvenile over to the adult system, where the juvenile may be tried as an adult and face criminal sanctions. There are two types of transfers under Ohio's juvenile justice system: mandatory transfers and discretionary transfers. Mandatory transfers removes discretion from judges in the transfer decisions in certain situations. Discretionary transfer allows judges the discretion to transfer or bind over an adult court certain juveniles who do not appear to be amendable to care or rehab within the juvenile system or appear to be a threat to public safety. I wonder which one Mackenzie is. She does not appear to be amendable to care or rehab for her behavior. And she is a threat to public safety. No. And this is why even her newer appeals, which kind of set out the same thing, argue that, it just didn't work. After a complaint has been filed alleging that a child is delinquent for committing one or more acts that would be an offense if committed by an adult, if any of those acts would be aggravated murder, murder, attempted aggravated murder, or attempted murder if committed by an adult, the juvenile court at the hearing shall transfer the case. If the child was 16 or 17 years of age at the time the act would be aggravated murder, murder, attempted aggravated murder, or attempted murder, and there is a probable cause to believe that the child committed the act charged. Yep. And she was 2 days shy of 17, or 2 days shy of 18. After a careful review, we disagree with the appellant's contention that the state failed to establish probable cause in juvenile court. In other words, if a child is eligible for mandatory bindover, and if probable cause exists to believe that the juvenile committed the act charged, the juvenile court must transfer. So they did what they were supposed to do. In any proceeding in which transfer of a case for criminal prosecution is required, by the statute upon finding probable cause, the order of transfer shall be entered upon finding a probable cause. To establish probable cause in a bindover proceeding, the state has the burden to present credible evidence supporting each of the elements of the offense. Probable cause in this context requires credible evidence that raises more than a mere suspicion of guilt, but does not require evidence of guilt beyond a reasonable doubt. Right. Probable cause is not beyond a reasonable doubt. It's different. Probable cause is a flexible concept grounded in fair probabilities, which can be gleaned from considering the totality of the circumstances. Probable cause is a reasonable ground for belief of guilt. It does not require a showing that a belief is correct or that it is more likely truer than false. In considering whether probable cause exists, the juvenile court must evaluate the quality of the evidence presented by the state in support of probable cause, as well as any evidence presented by the respondent that attacks probable cause to determine whether the state has presented credible evidence going to each element of the offenses charged. However, while the juvenile court has a duty to assess the credibility of evidence and to determine whether the state has presented credible evidence going to each element of the charge offense, it is not permitted to exceed the limited scope of the bind-over hearing or to assume the role of the ultimate fact finder. Right. They were not the ultimate fact finder. It was a probable cause hearing. And if they had probably done this, then at her age and those acts, it had to be moved to adult court. Yep. At trial is where the reasonable doubt standard came in. Phil. Welcome, by the way. The juvenile court's probable cause determination in a mandatory binding over proceeding involves questions of both fact and law. As a result, our review of the juvenile court's decision is mixed. We defer to the juvenile court's determinations regarding witness credibility, reviewing those determinations for abuse of discretion. However, whether the state has presented sufficient evidence to support a finding of probable cause is a question of law. We review de novo without any deference to the juvenile court. At this stage of the proceedings, the state was not required to prove the truth of the allegations against Shirilla. It had to present credible evidence showing probable cause supporting each of the elements of the offense's charges. Based on the evidence presented at the probable cause hearing, we disagree with Shirilla that the state failed to meet its burden. As detailed above, the evidence established that Shirilla pressed the accelerator pedal 100, causing the vehicle to reach, crashing, killing the people. Whether there was probable cause to commit murder turned essentially on whether there was a credible evidence that Shirilla purposely caused the crash. There was. Shirilla was examined by medical professionals after the accident. There was no medical evidence that she suffered any adverse medical event that caused the crash. The vehicle was examined. It wasn't a mechanical failure. The state also presented credible evidence of potential motive about the ending of the relationship in the previous thing and that she had threatened to crash the car before. While there was evidence suggesting that Mackenzie communicated that Russo was at fault for the highway incident, and while the state could not present evidence establishing that Mackenzie was angry at Dominic or otherwise upset immediately before the crash, the state only needed to establish probable cause at this stage of the proceeding. After reviewing the evidence presented at the juvenile hearing, we conclude the state did establish probable cause, and therefore there was no error when the juvenile court transferred the case to the adult court. We overrule Mackenzie's first assignment of error. So they don't agree with any of Mackenzie's errors. In the fourth assignment of error, Mackenzie contends that the trial court erred by allowing the state to introduce what she characterizes as improper character or other acts evidence pursuant to the evidence rules 404B. The state had filed both a notice of intent to use other acts evidence, as well as a motion to introduce other acts evidence, including evidence that on July 17th, 2022, Mackenzie had threatened to crash the vehicle. during a disagreement, and she was observed hitting him with her hands during an incident with Dom. Also, the notice indicated that the state intended to introduce evidence that on occasion in July 2022, Mackenzie came to Dom's home and, when refused to allow entry, angrily yelled at him, beat on the door, and threatened him. Yes, because Mackenzie is so nice. The trial court granted the state's motion. The state stated that this evidence was not being offered to show Mackenzie's bad character, but rather to prove Mackenzie's motive, intent, knowledge, absence of mistake or accident, and provide contact with respect to Mackenzie's relationship with Dom. Right. Because everybody wants to say, oh, it was lovey-dovey. And so this was their way of saying, yeah, this relationship is not the way her and her parents describe it. Or as the older produce lady describes it, and friends that are biased. You needed to see the other side of her, not the fake one that showed up to court. Shirilla's past threats and aggression towards Dom provided an important perspective of how Mackenzie responds in situations where she is displeased or in a disagreement with others. Further, the evidence shows that Mackenzie was aware of her ability to cause harm to victims, especially by means of her own vehicle, and how she could use the power of threats and control to ultimately reach the outcome she desired. Yeah, because she throws a tantrum like a 2-year-old. Ah. What just happened here? Okay. Yes, I'm glad she was not in juvenile court, Phil, because, yeah, she would have been released at 21. And she's not that, so thank goodness. Yeah, she's a menace to society, Keith. That is for sure. But yeah, she has to just throw her little fits. Pursuant to 404B, evidence of any other crime, wrong, or act is not admissible to prove person's character in order to show that on a particular occasion the person acted in accordance with the character. However, evidence of other crimes, wrongs, or acts may be admissible for proving for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. The key is that the evidence must prove something other than the defendant's disposition to commit certain acts. Thus, while evidence showing the defendant's character or propensity to commit crimes or acts is forbidden, evidence of other acts is admissible when the evidence is probative of a separate non-propensity-based issue. Because you know what I didn't hear in all of this stuff that's stated? I didn't hear that they brought in during trial that they broke into a church. If they wanted to just bring in bad character evidence, they could have brought in that stuff. But they didn't bring that in. It was to show the relationship that her and Dom had. It wasn't just to say, look, Mackenzie's a bitch. For other acts of evidence, the other acts of evidence must be relevant. The other acts of evidence must be introduced for the purpose other than proving propensity, such as one or more of the permitted purposes set forth in 404B. The probative value of the other act's evidence must not be substantially outweighed by the risk of unfair prejudice, confusion of the issues, or misleading the fact finder. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to determination of the action or more probable or less probable than it would be without the evidence. And that was evidence rule 401, but evidence rule 404B context, however, the inquiry is not whether the other act's evidence is relevant to the ultimate determination of guilt. The proffered evidence must be relevant to a legitimate non-propensity purpose, and the non-propensity purpose for which the evidence is offered must go to a material issue that is actually in dispute between the parties. Which, to me, the dispute is that they were great and they were not great. The relevance examination asks whether the proffered evidence is relevant to a particular purpose for which is offered, as well as whether it is relevant to an issue that is actually in dispute. Courts are precluded from admitting improper character evidence under 404B, but have discretion to admit other acts evidence that is admissible for a permissible purpose. Here, the challenged evidence went to a material issue that was actually in dispute between the parties. Whether Mackenzie purposely crashed the vehicle. Evidence that Mackenzie and Dom were fighting in July of 2022, including days before the crash, that Mackenzie had threatened Dom and that she had threatened specifically to crash a vehicle in which they were both driving was directly and meaningfully relevant and probative to Mackenzie's motive, intent, and lack of accident or mistake in crashing the vehicle. After careful consideration, we find the probative value of this evidence for the non-propensity purpose was not substantially outweighed by the risk of unfair prejudice, confusion, or issues or misleading the fact finder. Shirilla also complains that Detective Hazoo testified that Shirilla was seen in social media photographs smoking marijuana in a vehicle. She says the only reason that was introduced was to portray her as an immoral drug abuser who was prone to engage in criminal activity. Yeah, and they say we disagree. Yeah, that's not why that was done. As an initial matter, we note that the defense opened the door to this line of questioning in its cross-examination of Detective Hazoo, focusing on the results of Mackenzie's blood draw that showed she had been under the influence of marijuana at the time of the crash. The context of the state's line of questioning was not to introduce propensity evidence, but rather to introduce relevant evidence probative to the non-propensity purpose of absence of mistake or accident. She was also being charged with drug charges. After a careful review, we again find the probative value of this evidence was not outweighed by unfair prejudice. So it was more probative than prejudicial. Because there was no error in the court's allowance of the challenged evidence, we overrule Shirilla's fourth assignment of error. Fifth assignment of error, Shirilla contends that a certain of the trial court's evidentiary rulings denied her a right to fair trial and prevented her from presenting a meaningfully complete defense. Specifically, she argues that she was prevented from cross-examining Hinch and Detective Hazoo regarding text messages Dom sent on the day of the crash. Defense counsel did not proffer to the trial court the substance of those messages, but certain of those messages were introduced in the juvenile court proceeding. So the appeals court did see them. The scope and limitation of cross-examination are matters within the sound discretion of the trial court. After careful review of the record, we find no abuse of discretion here. First, Shirilla suggests that the trial court excluded The additional text messages themselves is not corroborated by the record. Shirilla complains about the following exchange during Hinch's cross-examination. I don't know how my computer gets undone all the time. Are you aware that day, the day of the crash, Dominic Russo texted Mackenzie Shirilla? Prosecutor said objection. The court sustained. Defense counsel said no further questions. Shirilla further complains about the following exchange during Detective Jesus' cross-examination. Defense counsel, you were asked on direct about text, correct? By the prosecutor? Jesus says, I don't recall. Defense counsel says, you don't recall? Jesus says, no. Well, Dominic Russo texted people that night that he loved them, correct? Prosecutor said objection. The court sustained, and they needed to go to sidebar. Come up here. The court. As for the last question, which clearly the detective was not asked on direct, is stricken from the record. Defense counsel, my apologies, Judge. Right, because your cross-examination has to be within what was mentioned on direct. And they can do that. In neither instance did the defense counsel attempt to lay a foundation establishing how Hinch could have known whether Russo texted Shirilla on the day of the crash, or regarding Jesus' knowledge of Russo's text messages. Right. He never was like, hey, have you seen these messages before? Are you aware of these messages? Did you see them in your investigation? Did you consider them? And he didn't even try to do. He really didn't try. After they were like, nope, sustained, he didn't try to fight for it or anything from the looks of it. More importantly, however, Mackenzie never attempted to offer the text messages themselves into evidence and did not proffer their contents to the trial court on the record. She seems to focus her appellate argument on a text message that Shirilla sent to a third party about the incident on July 17, 2022, where it was about Dom grabbing her steering wheel and trying to cause the accident. And that it had resulted in. She does not offer an explanation as to how either of the trial court's evidentiary rulings identified above, which concern Russo's text messages to others, had the result of excluding a message Shirilla sent to a third party. Right. So the defense attorney, what they should have done, and we saw a proffer. We saw quite a bit of proffering in Depp v. Heard, where they're right, like, okay, we didn't get to put this evidence in. This is the evidence, and this is what this evidence would have shown. And you put it on the record, and you make a record for it so that the appeals court can consider it. But if you don't put it on the record, it can't be considered. And there was no proffer made. So in the absence of a proffer, and having been directed at only these two evidentiary rulings, neither of which seem to exclude further foundation and development into the text messages that Shirilla claims were excluded, and where defense counsel chose not to delve into the areas with these witnesses, we cannot find an abuse of discretion in the evidentiary rulings identified. We therefore overruled Shirilla's fifth assignment of error. After oral arguments, the parties were ordered by this court to brief the issue of whether or not there was compliance in the matter with RC, a rule, and the effect, if any, on the assignments of error and or verdict if there was no compliance. Ohio Revised Code 313.19 states that cause of death and the manner of and mode in which death occurred, as delivered by a coroner and incorporated in the coroner's verdict and in death certificate filed with the Division of Vital Statistics, shall be the legal accepted manner and mode in which such death occurred, and the legally accepted cause of death, unless the court of the common pleas of the county in which the death occurred, after a hearing, directs the coroner to change his decision as to such cause and manner and mode of death. The Office of Cuyahoga County Medical Examiner conducted autopsies on the persons of Dom and Davion. The coroner's verdict, dated September 12th, 2022, as to the manner of death of Davion, was recorded as accidental. The report of the autopsy of Dominic Russo, dated October 12th, 2022, was also listed as accidental. Both autopsies were conducted by Dr. Joseph Fellow, a forensic pathologist and chief deputy medical examiner, and that Fellow testified that March 2023, he was asked by the office of the Cuyahoga County prosecuting attorney to review additional documents which had been generated by Strongsville Police Department, but were never submitted to the office of the medical examiner. According to Dr. Fellow, after he reviewed documents submitted to him, he changed the manner of death of both Davion and Dominic from accident to homicide. In the case at bar, the record is void of any evidence that the Cuyahoga County Medical Examiner complied with the statute. In her supplemental brief, Shirilla argued that the medical examiner lacks the statutory authority to amend a determination as to the manner and mode of a person's death as memorialized in a verdict and death certificate without being ordered to do so by a court. She directed this court to a different case in which the Supreme Court wrote that the coroner's factual determinations concerning the manner, mode, and cause of the decedent's death as expressed in the coroner's report and death certificate create a non-binding, reputable presumption concerning such facts in absence of competent, credible evidence to the contrary. Shirilla argued that the medical examiner's amending conclusion that Russo and Flanagan's deaths were homicide resulted in impropriety and prejudice. She further argued that the amended autopsy reports were created solely for the purpose of using them against her in this criminal trial and were thus testimonial statements implicating the confrontation clause. The state responded by arguing that Shirilla waived all but plain error as to these issues and that RC 313.19 does not apply when a medical examiner decides to change its own determination. As for the confrontation clause argument, the state directs to State v. McFeature. The state is correct that we review these issues for plain error because neither was raised below. After a careful consideration, we decline to find plain error here, but do caution the state as they need to comply with RC 313.19. So they needed to go through the proper things. But the judge is not going to put as much weight on a death certificate as maybe a jury would. Sometimes you're not even allowed to mention what it was classified as because it doesn't actually matter. That was one person's opinion. The Supreme Court has instructed courts to notice plain error with the utmost caution, under exceptional circumstances and only to prevent a manifest miscarriage of justice. Paragraph 3 of the syllabus, in order to show plain error, a defendant must evidence an error that constitutes an obvious defect in the trial proceeding and demonstrate that the error affected the outcome of the trial. We are not convinced, or we are convinced not to exercise our discretion to find plain error here because we are not convinced that any error was obvious or that the amendment of the autopsy conclusions affected the outcome of the trial or resulted in a manifest miscarriage of justice. We find that in the case, the change to the manner of the death of Davion Flanagan and Dominic Russo by the office of Cuyahoga County Medical Examiner did not affect the verdict in this case. Although the trial court had before it evidence of change as to the manner of death by the Cuyahoga County Medical Examiner's office, there was other evidence to support the verdicts. Dr. Fellow testified that it was his choice to amend the conclusions. He summarized what he reviewed in coming to the determination, and he identified the reasons why he came to those conclusions. In other words, the fact finder heard the circumstances of the amendment and could judge those circumstances as well as the credibility of that evidence that caused the amendment. Finally, in light of precedent from this court, any error in the procedure under the circumstances would not be obvious. The court has held that RC 313.19 contemplates situations where a third party seeks to have a trial court direct a coroner to change the manner of a person's death, unlike the situation here. And she also got to confront that medical examiner. Having overruled assignments of error for the reasons stated above, we affirm. The court finds there were reasonable grounds for this appeal, unlike Gingers's appeals. They had legitimate reasons to file. It is the order that the appellee recover from the appellant the cost herein taxed. It is ordered that a special mandate issue out of the court directing the Cuyahoga County Court of Common Pleas to carry this judgment into execution. The defendant's conviction having been affirmed, any bail pending is terminated. Certified copy and all that. It was signed. So, yeah, threatened to key his vehicle, threatened to commit a lot of crimes. That she did. But that is, I think, going to be it for me today, guys. I don't. Okay. So, I hope you guys have a great evening. I will figure out something for us to do tomorrow. I'm not exactly sure what time, because I do have to work tomorrow. But we will do something. And y'all get some food, get some sleep. Don't forget to hit the like button on your way out. And goodbye.